Good afternoon. I'm quite, thank you very much, Kokott, for inviting me to this very interesting conference regarding the Brussels regime and political questions, and in particular mutual trust in times of the judiciary crisis in Poland. We do have many proceedings regarding Poland. The day before yesterday, the Commission handed in its violation complaint against Poland because of sudden early retirement ages of the Polish Supreme Court. And also Polish judges are often submitted to disciplinary procedures for the mere fact that they ask us preliminary questions, and we have preliminary questions whether this is in conformity with European Union law. Of course not, but in this regard, the question arises whether it's the competence of the court, because these are theoretically internal proceedings. And then we have proceedings concerning our topic now. Mutual trust. Can people be delivered, for example, from Ireland to Poland, even though there are those really grave problems regarding independence of the judiciary? And this really puts us before very hard questions, because we know many of the Polish colleagues, and for example, in the summer we had a delegation from Poland, and many of those judges are really very courageous people, and it's hard to distrust at least most of them whom we know and who fight for the independent judiciary. On the other hand, even those very courageous people can be put under pressure, and so it's really a very difficult situation we are in. And so I'm even more looking forward to Professor Zuzanna Witek's presentation. You have the floor.
Excellencies, ladies and gentlemen, it is a great honor for me to be here today at this colloquium at Max Planck Institute. I very much appreciate that I can discuss such an important issue as the crisis in the Polish judiciary and its legal consequences with such illustrious group. As the title of my speech reveals, I would like to explore loss of mutual trust as a ground for refusal of mutual recognition in the framework of the European Union's area of freedom, security and justice. I will analyze the problem on the example of a judiciary crisis in Poland. The principle of mutual trust, or a high level of confidence, is a constitutional principle of the EU having the basics in the Union of Values, which are commonly shared by its member states. Under mutual trust, one member state should accept and enforce decisions of another member state as if they were its own. However, the principle of mutual trust is not blind. Trust must be earned by each member state through effective compliance with EU fundamental rights standards. The blind trust towards Poland has already been challenged, and its restoration in the future probably will be difficult. The status of Polish courts raises a lot of controversy, which is evidenced, for example, by the procedures initiated by the European Commission and launching for the first time Article 7 TEU procedure. The purpose of my speech is thus to explore hypothetical grounds for refusal of Polish judgments recognition. My speech will be divided into two sections. Section 1 looks at the meaning of the court within the EU law and confronts it with factual situation in Polish judiciary. Section 2 concerns the principle of mutual trust and then the legal consequences of its violation. In particular, it is important to analyze the LM judgment. In the end of my speech, I will try to prove that the LM judgment may be the beginning of non-recognition of judgment issues by the Polish courts, or in the very extreme version, if the Article 7 procedure will be completed, by the first stage of Poland's exclusion from the AFSJ. Functioning of the AFSJ is based on close cooperation between all member states' courts. National courts play an important role in securing the effective protection of the rights that the EU confers on individuals. The domestic courts must be independent, as it follows directly from the constitutional traditions common to the member states. Court disputes should be resolved by an impartial and independent arbitrator, whose task is to guarantee that the law is observed and whose judgments are to be respected and enforced by the parties and by the political branches of government. The functioning of the national courts with accordance to the rule of law is the basis of mutual trust. Therefore, the judicial independence is of pivotal importance. It is an essential component of the rule of law. As indicated in the recent Portuguese judge's case, member states must ensure that the national courts within the meaning of the European Union meet the minimum requirements of effective judicial protection. In the scope of the AFSJ, judicial cooperation is possible between judicial authorities which are independent. For this reason, only a decision made at the end of a judicial independent procedure satisfying the requirements of the second paragraph of Article 47 of the Charter can enjoy mutual recognition within the AFSJ. In this context, we should consider whether judgments issued by Polish courts during the concrete judicial procedure fulfill the conditions of premises which should characterize the court and the judgment on the basis of the Court of Justice case law. According to the abundant judgments deciding whether a given body is a court within the meaning of EU law, one should consider a number of factors, such as whether the given body is established by law, whether it is permanent, whether its jurisdiction is compulsory, whether it applies rules of law, and whether it is independent. Therefore, the national courts should function in a lawful manner and should be independent of any pressure, including political influence. Confronting the above-mentioned requirements for the court with the factual situation in the Polish judiciary, the following research question should be posed. Are Polish courts established by the law and are permanent? Do Polish courts apply the rule of law? Are Polish courts independent? Are Polish courts complying with EU law and particularly with the fundamental rights recognized by EU law? If at least one of these answers is negative, can it be the basis of non-recognition of the Polish judgments? In order to answer the above questions, I will make a legal assessment of new acts concerning the Polish judiciary. The judiciary crisis in Poland began in October 2015, and in the end of 2017, according to the European Commission, crisis has extended to include 13 laws affecting the entire structure of the justice system in Poland. The beginning of the judiciary crisis in Poland was caused by amendments in the Polish Constitutional Tribunal. According to the Article 194 of the Polish Constitution, judges of the tribunal are to be elected by the parliament, which is sitting when the terms of the previous judges expire. In October 2015, the outgoing Polish parliament, on the last meeting day, led by Platforma Obywatelska Party, elected 5 new Constitutional Tribunal judges in places of judges whose mandate expired in few weeks only after the election. After the parliamentary elections, in which Prawo i Sprawiedliwość party won and formed the government, it made its own unconstitutional appointments. Furthermore, in the middle of the night, the Constitutional Tribunal Act was suddenly amended. Moreover, for a long time, the publication of the tribunal's judgments was suspended. Some of them have not been published until now. After the systemic changes in the Constitutional Tribunal, the governing party's next step was to restructure National Council of the Judiciary, the Supreme Court, and the ordinary courts, which was undertaken all at once for the law in 2017 and 2018. the National Council of the Judiciary in Poland. The Council is a constitutional body responsible for protecting the independence of judges and courts. As a result of changes adopted in 2015, the Parliament, contrary to the Article 187 of the Constitution, gained almost exclusive competence to elect new members of the Council and, in consequence, gained control over the process of appointing new judges of the common courts. In September 2018, the European Network for the Councils has suspended the membership of Poland's National Judiciary Council, setting laws eroding the judicial branch's independence. The Supreme Court. The court plays a crucial role in sustaining the independence of the Polish justice system. The new Polish law on the Supreme Court lowers the retirement age of Supreme Court judges from 70 to 65, putting 27 out of 72 judges of Supreme Court at risk of being forced to retire. This measure also applies to the first president of the Supreme Court, whose 7-year mandate, served out in Article 183 of the Polish Constitution, would be prematurely terminated. That new law raises particular concerns in relation to the separation of powers and to the principle of irremovability of judges, which is a key element of the independence of judges, confirmed in the case law of the Court of Justice and of the European Court of Human Rights and European standards. Common courts. In 2017, the governing majority adopted changes which give the Minister of Justice the discretion to dismiss and replace the presidents and deputy presidents of all common courts without any justified reason. The governing party has dismissed over 150 out of 700 presidents and judges of ordinary courts. I have presented the most important changes in the Polish judiciary, which are contrary to the constitution. However, there are many more legal changes in the Polish judiciary, like the new acts concerning the National School of Judiciary and Public Prosecution. Having regard to the above, it is questionable whether the Polish courts fulfill their obligation under Article 19.1 of the TEU, read in connection with the requirements of the second paragraph of Article 47 of the Charter. In particular, the independence of the Polish judiciary is doubtful, both in the internal and external dimensions. Event in Poland led the European Commission to open a dialogue with the Polish government in January 2016 under the rule of law framework. In July 2017, the Commission launched an infringement procedure on the Polish law on ordinary courts, also on the grounds of its retirement provisions and their impact on the independence of the judiciary. The Commission referred the case to the Court of Justice in December 2017. The case is pending before the court. Furthermore, due to lack of progress through the rule of law framework, the Commission activated the Article 7.1 procedure for the first time and submitted a reasoned proposal for a decision of the Council on the determination of a clear risk for serious breach of the rule of law by Poland. Considering lack of progress on this issue in the rule of law dialogue with Poland, the Commission issued a letter of formal notice to Poland on 2nd July 2018, clearly setting out the Commission's legal concerns. The Commission subsequently sent a reasoned opinion to the Polish authorities on the matter in August 2018. In September 2018, a second hearing on the rule of law in Poland was organized in the General Affairs Council in the context of the Article 7.1 procedure. The Polish authorities again stood by their position and refused to propose any measures to address the concerns of the Commission and other member states. On 24th September, 2 days ago, the European Commission decided to refer Poland to the Court of Justice due to the violations of the principle of judicial independence created by the new Polish law on the Supreme Court, and to ask the Court of Justice to order interim measures until it has issued a judgment on the case. Likewise, the crisis in Poland has been met with a response of all independent human rights institutions, including Venice Commission, United Nations Human Rights Committee, Parliamentary Assembly of the Council of Europe Commissioner for Human Rights. In the first part of my speech, I have focused on the meaning of the court. The basic component of the courts, the judicial independence, is a fundamental condition for courts of different member states to trust each other and to cooperate within the EU judicial system. The principle of mutual trust is a constitutional principle that pervades the entire AFSJ. Nevertheless, the principle of mutual trust is not defined in the treaties. In the opinion 2/13 concerning the EU accession to the European Court of Human Rights, the Court of Justice highlighted the fundamental importance of that principle since it allows an area without internal borders to be created and maintained. That principle requires, particularly with regard to the AFSJ, to consider all the other member states to be complying with EU law and particularly with the fundamental rights recognized by EU law. In the Achmea case, the court admitted that EU law is based on the fundamental premise that each member state shares with all the other member states and recognizes that they share with it a set of common values on which the European Union is founded, as stated in the Article 2 TEU. That premise implies and justifies the existence of mutual trust between the member states, that those values will be recognized, and therefore that the law of the EU that implements them will be respected. Having regard to the above, the principle of mutual trust has two dimensions. One, the presumption of compliance with EU law, in particular fundamental rights by other member states, opinion 2/13, paragraph 191, and the inability to rely on higher constitutional standards by the member states when EU law harmonizes some fundamental lines, what I derive from the Meloni judgment. The EU has adopted at least 26 legal acts in civil and criminal matters, which are based on the principle of mutual trust and mutual recognition. Therefore, it is questionable whether the breach of the principle of mutual trust can be the basis for non-recognition. The EU legal acts differ in the mechanism of mutual recognition and decisions and formats, or the reason for refusing to recognize or enforce the decision. However, in all acts, recognition and enforcement is a rule, and the refusal is possible only in strictly defined circumstances. These acts, although have different recognition mechanisms, have common features. They provide for the automatic recognition of judgments, prohibit the control of jurisdiction or substantive review of judgments from another member state. The fundamental act in this field, the Brussels Regulation, provides for automatic mutual recognition and automatic enforceability of judgments. However, according to the Court of Justice case law, mutual trust must not be confused with blind trust. The concept of mutual recognition is restricted, flexible, and quasi-automatic. The presumption of compliance by other member states with EU law and fundamental rights standards can be challenged. The Court of Justice allowed, in exceptional cases, the possibility of examining whether another member state respects fundamental rights, even if the given legal act does not provide non-recognition procedure. Referring the above to the Polish case. Restricting the judicial independence in Poland is a new challenge for the AFSJ, and its factual consequences will only be known in the future. At present, we can only rely on the LM judgment. Case law in this area will centrally develop. In the LM judgment, the respondent in the main proceedings, prosecuted for a drug-related crime, was the subject of 3 arrest warrants issued by Polish courts on the basis of the framework decision. Due to the reforms in Polish judiciary, the respondent revealed a real risk of not receiving a fair trial if he is transferred to the country. In March 2018, the Irish High Court held that the legislative reforms adopted in years 2015 and 2018 in Poland, taken as a whole, breached the common value of the rule of law referred to in Article 2 TEU. Based on this finding, the High Court has referred 2 questions for determination of the Court of Justice. The High Court raises the issue whether the second stage of the examination defined by the Court of Justice in the Aranyosy case find application in the LM case, where there is a grave risk that the member state breach the rule of law. In the above-mentioned LM judgment, the Court of Justice confirmed the importance of the principle of mutual trust and mutual recognition. Furthermore, the court corroborated its position from the Aranyosy judgment that the principles of mutual recognition and mutual trust between member states in exceptional circumstances may be limited. Afterwards, the Court of Justice confirmed that the domestic courts within the AFSJ should apply both 2 steps of the Aranyosy test in case of suspicion whether a member state has infringed fundamental rights. The Court of Justice stated that constant suspension of mutual recognition mechanism is possible only if decision on the basis of Article 7 TEU is taken in connection with the violation of Article 2 TEU. Until the decision is made, a warrant may be suspended only in individual case if there are substantial grounds for believing that the person will run a real risk of breach of the fundamental right. From a practical point of view, the judgment clarifies the procedure on how the court should proceed if the person in respect of whom a warrant has been issued places that there are systemic or generalized deficiencies in the independence of courts in the issuing state. In such case, the executive court is required to make an assessment of the risk in the individual case, which consists of 2 steps: a systemic assessment and a specific one. The LM judgment is for some a breakthrough due to the possible limitation of mutual trust. For others, the judgment does not establish sufficient consequences of violating the judicial independence and is too focused on the rights of the individual instead of developing the line of jurisprudence initiated in the Portuguese judgment. Certainly, the LM judgment introduces specific duties for the national courts and reverses the principle of mutual trust in the Article 7 TEU procedure will be completed. Moreover, it requires an individual control whenever the person under European arrest warrant requests it. This may significantly weaken the effectiveness of the European arrest warrant mechanism and can cause numerous attempts to refrain from applying Polish decisions. Concluding, the consequences of changes in the Polish judiciary system may be political, financial, and cause loss of reputation. But within the AFSJ framework, the most important consequences of the situation in Poland are the legal sanctions, for example, loss of mutual trust in the relation to the Polish court's judgments. It is not known yet how far the member states will not recognize the judgments of Polish judiciary based on the loss of mutual trust. It depends on many factors. Whether the crisis in Polish judiciary will deepen, how the Article 7 procedure will be concluded, how the national courts will perceive the Polish judiciary system, how often individuals will rely on LM judgment and Aranyosy procedure. In the very extreme version, until the rule of law is restored, Poland will be temporarily excluded from the AFSJ. Such a scenario would be possible in circumstances if the Council, under Article 70 EU procedure, will found Poland breaching the rule of law and found that Poland does not meet the EU's fundamental rights standards. In the least serious version, the burden of assessing the rule of law in Poland and observance of the fundamental rights standards will belong to the national courts under the Aranjuezi two-steps procedure, in which an individual assessment will be required each time in every case. Probably the next few months will give us the answer to the question concerning the future of the Polish judicial system in the European Union. In the end, I just want to mention that in my speech, as the title reveals, I have focused on loss of mutual trust as a ground for non-recognition. But under the Brussels regime, there is one other ground for non-recognition, the public policy clause, which was previously mentioned by Janek Nowak. A few weeks ago, the German Supreme Court in Karlsruhe refuses to enforce Polish judgments for violation of the German Ordre public. The judgment in question concerns the ZDF television, which described Majdanek and Auschwitz camps as Polish extermination camps instead of German extermination camp on Polish territory. By many, the decision of the German Supreme Court is contrary to the Meloni judgment. Furthermore, the German court made a substantive assessment of the Polish judgment, which raises a lot of controversy. Thank you very much.
Yeah, thank you very much for this most impressive description of a very sad situation. I would like to give the floor to the public before I make some comments. Maybe you would like to ask questions or make comments on the situation. What is sure is that the challenges for national first instance judges are tremendous. Of course, we have Poland, and there you might say that there are some guidelines or some general feeling, but there are so many other countries where it's not sure whether you can extradite a person or not under the Aranjuezi judgment. I think the judiciary is really put at its limits, and those poor judges now have to find out in how the political situation in what country is and how the prison conditions are, how the detention positions are. I think it's overburdening the national judges, and I had some talks with national judges just at the beginning of this week, and some of the ideas are that the European Court of Justice should make guiding decisions, saying, for example, that Turkey is a sure country, you can put people to Turkey, Poland is not, just examples, yeah? But I think that's not the solution, because the situation in many countries can change very quickly, and in order to have a guiding decision of the European Court of Justice or of some other high court, you must have a case which goes through all the instances ending up, and until that, then the situation might have changed. So if you want to have guiding decisions, it should probably be the executive, and those guidelines with regard to countries might be necessary, because we have now the situation that judges in one member state recognize refugees. It's a different subject, but nevertheless there are some similarities. 10% of a certain country, they give 10% asylum or protection, and in other countries it's 99%, and something must be wrong. So I think the challenges for the judiciary in mutual recognition, but also in other areas, are really tremendous these days, and maybe we ask too much of the judiciary. And also one must keep in mind that even not the Court of Justice. We can try to help to solve the Polish problem, but it's very difficult for a court, because a court is no army. We need to have acceptance of the states, and it's always a very, very difficult task. I mean, the situation with regard to the Polish Supreme Court is quite clear. We had a very similar case in 2012 when Hungary put its highest judges, suddenly put the retirement age from 70 to 62, and then wanted to replace those elder judges by younger judges who are with a different political opinion. But the court clearly said this is discrimination on the basis of age, and I think the situation in Poland is quite similar. But there are also tiny signs of hope. We have this violation procedure handed in the day before yesterday, and today I heard that I think yesterday the appointment of new judges to the penal chamber of the Polish Supreme Court has been suspended. It's a tiny thing, but I was very glad to hear this. So I made the first comment. Meanwhile, you could think of some questions.
Well, in civil cooperation, the situation might maybe not as problematic as in criminal matters. You already alluded Article 45 of the Brussels 1 bis regulation. There is at least, let's say, a way out. There is a public policy exception which might be invoked much more often now before ordinary courts because a debtor who is confronted with a judgment coming from Poland might be inclined to defend the case under the public policy exception. On the other hand, and this is my point here, we have the Brussels 1 bis regime, which is much difficult from the older regime. So now we are in the national enforcement procedures, and the public policy defense will be raised in local courts, first instance courts, so in the national environments. It was different under the Brussels 1 regulation, where you had the possibility to raise it in the second instance, but in front of a court of appeal, which is a more experienced court. And in addition, there is certainly a situation which has not been foreseen, and we already talked about it. We have constellations in European civil procedure law where no public policy exception is any longer foreseen, and the question will be, what shall a national judge do? He or she should at least send the case to the Court of Justice, deciding against the wording of EU secondary law might be very much problematic. So at the first sight, I would say these traumatic situations in the Polish judiciary might affect more other areas than civil cooperation, but at the second side, one can see that we also have maybe increased conflicts. And we have not yet talked about, and this is an area which is very much sensitive, family law, child abduction, and the questions, who is deciding about the situation of the family when I have to go back with my child from, let's say, Sweden to Poland and vice versa. So I think we have a lot of questions here, and I do agree the whole system is under stress, and the possibilities of the judiciary are limited.
I saw some hands down.
Yes, my comment comes from the idea that I had listening to you, because my background is also one of Eastern European countries that's under the stress, or the judiciary and the legislation is going through changes in Romania. And then I was thinking whether certain changes that happened in Hungary, that are happening in Poland, and kind of are in sight to a certain extent in Romania, do have common lines, and we are heading towards developments in what is judicial independence, rule of law, and previsibility. Maybe it's something to think of for the future, because I think there are common lines in these reforms in all three countries. Of course, there are also differences, but
I can agree with you that there are some common lines, and I think that the European Union was not prepared for such a serious crisis in Poland. All mechanisms are quite new. For example, the non-recognition and the loss of mutual trust, and we will see what will happen in the future on this European Union ground.
Yes, and I think the principle has been restricted already in those last years. Couple of years ago, it was more or less automatic, and it was kind of a scandal touching the founding principles of the European Union. If one judge examines or has closer look to some judgment concerning child custody of another member state, but then we had a discussion with our constitutional judges of Germany. And then, first of all, I also had some doubts. You cannot be blind, not completely blind, even not among normal, even without crisis, you can not always be 100% blind. So I had my own doubts, but it was nevertheless considered kind of scandal when the European Court of Human Rights put some automatic recognition into question. And then we had discussions with the German Constitutional Court, and they said if you apply mutual blind trust, we won't support that. Yeah, and we had really good discussions, and now even with our court, it's no more blind mutual trust. That's clear, and even without crisis, there is not blind trust anymore. Yeah, but it makes things much more difficult for the judges, for the responsible judges. Yeah.
Thank you. I agree. Thank you for a very interesting speech and for also so far very interesting comments on a extremely complex situation. But I think that the discussion shows, and also the last comments show that, I mean, we have come further after some years. We have come quite far in our mutual trust, in a sense, debate and discussion. So there is quite a common ground I see emerging in the fact that we cannot have this blind trust. And we haven't mentioned the legislature, because if you compare the civil justice measures to the criminal and the immigration measures in the area of freedom, security and justice, you can see that in the civil justice measures, I had argued also previously that there are actually more safeguards in the civil measures. Even in the harmonizing measures, there are more safeguards, more stop possibilities. Even when removing certain refusal grounds, we have built in certain minimum guarantees. And of course, we are now analyzing whether they work. But I think that it's important that we include the legislature if we need to go to support mutual trust. One way would be to also add, maybe put in these measures more safeguards or more outs for the national judges, maybe in different ways, particularly in the measures that have imposed completely blind trust, which the judges have also as you say, will not accept and which have shown themselves problematic. And I think the legislature might also be one part could add help to this. It's not nice going back on the idea of the political idea of we are all equal and we all accept each other, but it's a way to protect also European integrity of mutual values, actually to have safeguards, not the other way around.
Thank you very much. When I look to the program, I think there are some closing remarks by Professor von Calster.
Thank you very much for the invite, Max Planck Institute, and particularly Professor Hess. It's been a real pleasure to be here today and to be here tomorrow and Friday as well. I think for many of us, this is a real mind fest. We don't often spend 2 or 3 days in the company of like-minded conflicts nerds. And that's always, I think, really very, very enjoyable. I think it's also wonderful that we have today an early career, or for want of a better word, an early career day, which I think is excellent. I've heard some amazing presentations. I have 6 things to say, also 2 comments or so before I say those things. First of all, of course, I will make them very brief. Especially as a beer-loving Belgian, I am acutely aware I have a huge responsibility in not keeping you too long here and having you enjoy some Luxembourg terraces and so on. I love these photos. I understand it must have taken some Max Planck researchers some time to get through the archives of European integration to find these pictures. We can only assume they actually are from the 1968 convention. It may have been just some of Professor Hess's neighbors dressing up in the 1960s style, but I suspect they're actually properly correct. There's one thing that I think hasn't changed between 1968 and now, and that's the travel time between Brussels and Luxembourg, especially by train, which is still always epic. I should have known, but I couldn't get away last night from Brussels. So 6 things I wanted to say. First of all, and they more or less, some of them I think link to what we've heard today, some of them probably don't. But I think hopefully still at least all of them link to the Brussels Convention and similar ideas. First of all, the idea, of course, of mutual trust. We've just heard even more about it. That I think has been really a common theme throughout the afternoon, and I'm sure will be tomorrow and Friday as well. Zuzanna refers in her paper, which I've had the privilege of seeing already, her draft paper refers to an article which I'm sure many of you have seen by President Leenaerts on mutual trust in, I think it's the Common Market Law Review. I could be mistaken. Anyway, an awful lot of talk about. There's also the Advocate General referred to it. I think there's a very idea of mutual trust not being blind trust in an EU of 28 member states. I stubbornly keep on saying 28. I will not mention Brexit in this talk. I think is going to be a very important theme. In private international law, it's been a guiding principle, not just of the way in which the convention was set up, but particularly in the way in which the European Court of Justice have interpreted the convention. Whether or not that should lead to some kind of a mutual recognition idea, also in substantive underlying law, again a theme that we discussed a little bit earlier today, we'll have to wait and see. There are some signs of that in, for instance, this collective redress mechanism, or in 1 or 2 parts of the insolvency regulation, position of insolvency practitioners, etc. I think is a sort of small step towards that, but we'll have to see where that will, what that will lead to. So first of all, mutual trust. Secondly, predictability. Another running theme in the Court of Justice's case law, the idea, which many of you will know, is not quite so familiar to the common law in conflicts. The idea that we should, before we even set out a contract with someone, have almost absolute certainty, not almost, have absolute certainty as to where we might end up in court, and so on. That idea of predictability, I think, is ever more challenging, especially given the complexity of rules and the ever wider scope of rules that we bring within the European conflicts family. It also, to some degree, creates some tension with more substantive ideas like, for instance, Fraus omnia corrumpit, the abuse of procedure, which the Court of Justice very tentatively sort of touches upon in Article 8.1, for instance, on anchor defendants, but not so much elsewhere, which, for instance, on the very international scope of conflict of laws, it hesitates, I think, justifiably to intervene too much. But the idea of fraus or abuse generally, it was mentioned also when we talked about mosaic jurisdiction and abusing that by bombarding defendants with 27 potential fora, etc., is one I think that we should look out for in the future. There are, of course, national mechanisms which do have, I think, more successful regimes to address this. This would also, I suspect, and that brings me to my third theme, international competition. International competition, the idea that conflict of laws is not just a part of what makes a jurisdiction attractive, but can also proactively be used to make that jurisdiction attractive. Whether we should have a European approach on that, I think many of you who know me or who follow me in various fora know that I'm not too fond of too much harmonization in procedural law. I think it's a very good thing, for instance, in interim measures and in civil procedure generally, that we leave member states enough space to experiment. Some great things come out of those experiments, and I would really hesitate to have too much of a European straitjacket that would confine us there. I don't think at the moment there is too much fear that that would happen in too restrictive a manner, but still it's something that I think we need to keep an eye out for. Of course, international competition is now very much in vogue in terms of these commercial courts, right? The fact that many European member states are creating these commercial courts, the fact that, this is a study led by Professor Roel for the European Parliament on whether we should have a European commercial court, right, to compete with the DIFC in Dubai or the Singaporean courts and so on. Very relevant topic. I mentioned that to a number of people over lunch, I think in quite a few member states there is a feeling, especially amongst legislators, that we might want to, perhaps in certain member states, including I think the one that I know best, which is probably Belgium, we might want to think first about making the rule of law work properly for everyone, and then perhaps use a well-functioning legal system as a kind of marketing board for our courts, rather than the other way around. And especially, I think, amongst MPs who need to approve all these things, that's a very valid argument, which might still hold some of these commercial courts, I think, in some of those member states, including, in fact, in Belgium, the Brussels International Commercial Court. But also competition in terms of an increasing attention to the international impact of European civil procedure rules. There are, of course, the classic things of to what degree our rules are perhaps too parochial, perhaps capture too much, but there's also the increasing interest to how those rules work internationally. Professor Hess referred to the issue of having to enforce, of course, these rules, and it doesn't really help very much if you include too many non-EU-based defendants, because your chances of recognition and enforcement might actually be fairly slim, and one needs to wonder what the point of it is all, especially given that 1968 we started specifically with the free movement of judgments. There's, of course, the pending case in Google France, which I think will be very relevant in that respect. To what degree should our right to be forgotten be extended to force delisting upon a non-EU-based company? Should we worry about those practical implications, or should we simply be dogmatically pure and not worry too much what will happen with those judgments at the very end? I believe more in the former perhaps than in the latter. A theme that we didn't address, but that I understand will be looked at in some way tomorrow and Friday, of course, is Luxembourg or The Hague. The Judgments Project, where is that going to go? Again, most of you are aware that in the Hague process to try and come up with something like an international convention on jurisdiction in civil and commercial matters, this is called the Brussels regime, the Brussels approach. But of course, The Hague don't have the kind of court like we have in the EU that has done a huge amount of work and has extremely been influential in making this a harmonized approach. And I still find it very difficult to see how we can have, I know that there are other mechanisms in the Hague process that help harmonization, but I still find it very difficult to see how all these concepts that are being used in the Hague Judgments Project, including the very concept of civil and commercial, when you have states like China and the United States and so on involved, and all the discussions that you see on just that very aspect of civil and commercial, I find it very difficult to see how that can function without that kind of a court system. That's not to say that we shouldn't try. But there again, we'll have to see where the Hague process will end up. And it's certainly not impossible that quite a few chunks will be taken out of the skeleton convention to leave perhaps a more streamlined and more selective harmonization model at the international level. My fifth comment might first of all strike you as slightly bizarre. It's upholstered furniture. You all know the Kolzani case, right? One of the very first, if not the first case, perhaps, that was judged by the Court of Justice under the then protocol applying the or interpreting the 1968 convention. Kolzani was about upholstered furniture, which often reminds me of one of the first cases I did as an EU lawyer, which was the customs classification of sliced mushrooms. That was very exciting. It kind of was actually for the trade lawyer, but so in conflict of laws it was upholstered furniture. Nowadays, when the Court of Justice hears cases on conflict of laws, it's still about upholstered furniture and so on, but it's also about many more personal things, parental kidnapping, evidently, Sharia law, things like the right to be forgotten, etc. That must have an impact. And that development between 1968 and now in terms of the European judicial area must have an impact on how the Court of Justice experiences these conflicts cases. Obviously, I don't sit at the court, but I would imagine that if you are a judge and you have, the parents of the child, etc., in the room or family members and so on, it's very different from just having, at the best, some legal counsel of the upholstered furniture company sitting in the same room. I think in terms of the dynamism of the court, the psychology perhaps, that must have an impact on how it deals with civil procedure, including the 1968 Brussels Convention and evidently now its successors. And finally, there is, of course, the recipe which many of us also, when we teach and research and practice conflict of laws at the EU level, always go back to. It's a safe bet to try and remember the basic principles, and I've mentioned some of them, which the Court of Justice always employs when it applies the European civil procedure rules. Things like, indeed, effectively what it does is it's taken an X-ray of the 1968 framework as it's continued, and it keeps on using that skeleton to apply even intricate problems like internet jurisdiction, etc., predictability, autonomy, and so on. It does that to great success, and interestingly, Advocate General Bobek, who was, of course, here this morning, I don't know whether you've seen that in his opinion in Phoenix, made a robust defense of that approach, right? Where he was very keenly aware of the difference between civil law, private international law, especially European private international law on the one hand, and the more common law approach. But he makes a robust defense of that because he says, frankly, it's about something else than the kind of classic national conflicts exercise, right? So those were 6 things I wanted to mention. 1 or 2 of you may have sussed out that if you add those 6 things, right? So you have mutual trust, predictability, international competition, Luxembourg or The Hague, upholstered furniture, and then X-ray, of course, you get MPI Lux. And I want to finish, therefore, by thanking again the organizers of today, tomorrow, and Friday for the invite and for putting on the conference. Thank you very much.